Item number 9, number 5510, sub A.
Chairman Craven.
Thank you, Mr. Speaker. This bill comes to us from Representative Tansey. It is involving protection of domestic violence victims, and it is my pleasure to deliver for consideration today this bill, which is designed to protect Rhode Island families from domestic abusers and criminals with guns. This bill is several years in the making and has had several hearings. It has been adopted to address the concerns from the opponents as well. 5510 does three things in its original form. Respects the Second Amendment. This bill would protect victims of abuse and respect the rights of law-abiding gun owners. Number two, it narrowly focuses on dangerous people. And when I say narrowly, I mean narrowly. This bill is narrowly tailored to target the most dangerous domestic abusers. Number three, it prohibits and requires surrender. This bill prohibits gun possession and requires surrender of firearms if you are under a final protective order from the family court or have been convicted of certain types of misdemeanors that are under the domestic violence statute, Chapter 12. The Sub A version of this bill addresses the concerns that were heard during the hearings on this bill. A, it clarifies who the bill will impact specifically with regard to convictions and orders of the court. B, at adding a process for those convicted of a misdemeanor domestic violence crime to file a petition to get their state prohibited guns lifted after 5 years following probation. And C, it outlines outlines a process rather for storage of guns, retrieval of guns, and abandonment of guns. Polling indicates that more than 80% of our constituents in this state support this bill. States with similar laws include 28 in number, plus the District of Columbia, that have prohibited gun possession by some abusers convicted of domestic violence crimes that are the types that are contained in this statute. Mr. Speaker, it is a good bill, and I urge passage. Thank you.
Chairman Craven moves passage. That is seconded by Leader Shikachi, Representative Casimiro, Representative Regenberg, Representative Amori, Representative Donovan, Representative Ranglin-Vassell, Representative Carson, Representative Tansey, Chairman Handy, Chairwoman Ruggiero, Representative Knight, Representative McEntee, Chairwoman Fogarty, Chairman Abney, Representative Agello, Representative Walsh, Chairman Jacquard, Representative Hearn, Chairman McNamara, Representative Blaise-Juski, Representative Tabone, Representative Cunha, Representative Maldonado, Representative Barrows. Whip Edwards. There are no lights. Clerk, unlock the machine. What? Okay. I waited 30 seconds. I was surprised there were no lights. All right, clerk, clear the board. Are there any lights? Clear the board, clerk. Thank you. Leader Morgan.
Thank you, Speaker. This bill has been advertised as a bill to fight domestic violence. And if it really did that, I think we'd all be in favor of it, because domestic violence is a terrible, abhorrent crime. But it doesn't. Nothing in this bill will stop domestic violence, because the gun doesn't do the domestic violence. It's the person that shoots or uses a knife or his hands or her hands or bludgeons. What this bill does do, I think, is fairly dangerous. Our Constitution is a very important document, and it preserves certain rights, constitutional rights. And there is not another constitutional right that is being threatened or can be taken away because someone committed a misdemeanor. A misdemeanor, and you're going to try to take a constitutional right away for a misdemeanor, not a felony. What other right can you think of that is threatened because someone commits a misdemeanor? Let's take one of those rights that is in the Constitution, the right to protest. We know that there are a lot of people who protest, and they are charged with misdemeanors because they disturbed the peace, because they made damage to some property. Should we say that those people should not be allowed to protest for 6 more years because they got a misdemeanor charge? That's how sacred constitutional rights are. Which other ones are we going to say you can't have because you've been charged with a misdemeanor? This goes to the heart of what we in America value, which is our constitutional rights. It is enshrined in the Constitution. The Second Amendment. And it's just as important as all those in the First and all the rest. This bill threatens that because someone committed a misdemeanor. So should we take away the right to protest? Perhaps we should put that bill in next year and strip offenders of 6 years of their right to organize and protest. This is a bad bill. It doesn't do what it says it wants to do. And what it does is threatens the constitutional rights of each of us. I urge you to vote against it.
Representative Roberts.
Thank you, Speaker. I don't know what part of shall not infringe we don't understand on this floor. But we are not supposed to touch that Constitution, as Rep. Morgan has said. We're going to make many of our constituents into criminals needlessly. I urge you to vote against this bill. Thank you.
Representative Natalillo.
Thank you, Mr. Speaker. As probably all of us in this room have received countless emails, probably a couple hundred emails from those in favor and those who are not in favor of this legislation. This weekend I actually took the time to reach out verbally via the telephone to the Second Amendment organization and supporters, and I thought I would hear from the individuals that were dead set against this bill for just the reason of firearms. So I would bring up the question, what is your position on the domestic violence aspect of it? And I heard out of 20 phone calls, 20 individuals say, we are concerned. We are concerned with making sure that our rights are not infringed, but the fact that serious domestic violent individuals do not get these firearms. But that's not what we're talking about in this legislation. And as the chairman presented this bill, he said that the organization was satisfied. Now, when I receive a couple hundred emails from the organizations that are pro-Second Amendment, and we're listening to their concerns and reading the legislation, I'm concerned as a representative for those who have suffered from domestic violence. We don't want to put them in the position where there is a violent offender giving them an opportunity to hurt them further with a firearm. This legislation, as Leader Morgan just said, it's not protecting from that. This bill needs to be recommitted again and understood in a perspective that is going to protect those individuals, but yet isn't offensive to our constitutional rights.
Chairwoman Ruggiero.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I rise in support of this bill. This is not a gun control issue, but it's a bill to protect domestic violence victims. It's not about someone protecting their home or their family, which everyone has the right to do. This is about someone who's been determined to be dangerous to him or herself. It brings Rhode Island in line with federal law that already prohibits a person who is convicted of misdemeanor domestic violence from having a gun. We don't want anyone who is mentally ill or who is violently dangerous to have access to a gun. It's also the exact same bill that South Carolina Republican Governor Nikki Haley signed into law in South Carolina. And the research shows when these laws are in place, there's a 25% reduction in intimate partner gun deaths. That in and of itself merits support of this bill. Thank you, Speaker.
Whip Philippi.
Thank you, Mr. Speaker. You know, Chairman Craven said that 80% of our constituents support this until they find out what's in it. We put a name like the Protect Rhode Island Families Act, and it sounds good. And I think pretty much all of us, if there's a true domestic abuser abusing a domestic partner, a spouse, a girlfriend, or a family member, I think a lot of us would support the notion in this bill. But this bill goes a lot further than those who are in a substantive dating relationship. It extends to anyone who cohabitates with each other. And then it takes away the court's discretion as to whether to remove the Second Amendment rights of individuals. The court shall remove firearms from anyone restrained in district court, anyone restrained in family court, and anyone convicted of a crime of domestic violence. Let's start with the restraining orders. As you know, Mr. Speaker, the standard for restraining orders is not beyond a reasonable doubt, which is the standard for a criminal conviction. It's not clear and convincing evidence. It's a mere preponderance of the evidence that the court needs to find to restrain someone in district court or in family court. And then if they find by a preponderance of the evidence that that person should be restrained, the court has absolutely no discretion. It must take away that person's Second Amendment rights. Many of us in this room have fought against mandatory minimums for a long time. This is a mandatory minimum. A mandatory minimum removal of a fundamental constitutional right. So let's look at, it's a long bill, so let's start in the beginning. Let's start with the district court restraining orders for domestic abuse. As I said, it applies to cohabitants. It does not require you to be in a substantive dating relationship. It could be two roommates. One roommate could throw a book at another roommate. That other roommate could run to district court, and if the court finds that the person attempted to cause physical harm, then the court would have no discretion but to take away the person's Second Amendment rights. When we go to family court, it's the same standard as above, attempting to cause physical harm or placing another in a fear of imminent physical harm. These are very vague standards. They're easy standards to meet on a preponderance of the evidence. And now, when we deal with criminal convictions, we have to have beyond a reasonable doubt, a finding of beyond a reasonable doubt, but it now moves misdemeanors into the category of convictions that could have your Second Amendment rights, actually that must have your Second Amendment rights taken. Disorderly conduct is now one. It must involve some type of attempted use of force or threatened use of a dangerous weapon. I'll give you an example. Two roommates, because this applies to people who cohabitate. One could be drunk and take a swing at their roommate. And if the cops come, find that person committed simple assault on a cohabitant, they have to take away the person's firearms for the length of that conviction. and beyond the conviction, actually, until expungement. So I could go on for hours because this is a long bill. The main takeaways: preponderance of the evidence standard, it's very low, no judicial discretion, fundamental rights are getting taken away. It's a mandatory minimum. And we mostly don't like a mandatory minimums unless it applies to guns. So it's a big problem. I'm sure I'll get up again on this bill, but if we were just to limit this to family members and those who are in a substantive dating relationship, I don't think it would be much of a problem. This is far too broad. We need to pull it back. Because there can be a lot of problems that we don't anticipate and a lot of infringements in here that can happen with the application of this proposal. Thank you, Mr. Speaker.
Representative Knight.
Thank you, Mr. Speaker. I rise in support of this bill, in strong support of this bill. Guns are allowed in our society. They're there by virtue of the Second Amendment of the United States Constitution. But like every single other amendment to the United States Constitution, it is not free from reasonable regulation. You can't yell fire in a crowded movie house, even though it might be your First Amendment right to do so. You can't let your actions, we can't let people's actions run roughshod over the rights of others. And the trick for us, and the trick for the courts and the executive and the rest of our government, is to find a way to balance all of those. When guns are prevalent in our community, particularly in domestic violence situations, they are available for people to use who have lost their tempers. And we have seen the tragic results of that time and time and time again in our society. In a domestic violence situation since 1980, roughly half of the homicide victims in Rhode Island who have been killed by their domestic partners have been killed with guns, because those guns were easily available. So this is not, frankly, a question of the government trying to strip people of their most important rights. This is a question of the government trying to find a reasonable balance to ensure the safety and security of our citizens against a public health threat that arises in the forms of firearm violence. With respect to some of the arguments that my colleagues across the aisle have made, I know that they are deeply held, but respectfully, most of them are dead wrong. Leader Morgan has indicated that for a misdemeanor, what other misdemeanor can you lose your constitutional rights? Well, I can think of a bunch of them, because a misdemeanor in our state, the maximum penalty for a misdemeanor is 1 year in jail. That's a loss of all of your rights. And we do it all the time if we find that somebody has violated the law and their criminal background and the facts of the situation are severe enough so that we think they ought to go to jail. We do it every day. Nobody does it lightly, but certainly just about every constitutional right they have is stripped away during their period of incarceration. For those, and if you don't want to think about jail, let's look at the Fourth Amendment, the rights against search and seizure. That right can be taken away at the discretion, sole discretion, of a police officer on the street. If you're pulled over, you're seized. If you're searched, you're searched. And our law specifies there are certain situations where it's okay for an officer to do that. Those rights are subject to reasonable regulation, and those are just two examples. Representative Nardolillo talked about the callers that he has talked to getting being concerned about domestic violence, as we all should be, and I appreciate that. But as someone who has prosecuted and defended well over 1,000 cases in my estimation of domestic assault, domestic disorderly, domestic trespass, cyber stalking, cyber harassment, domestic assault with a dangerous weapon, domestic burglary, and on, I'll tell you that the ones you got to watch out for are the ones who come through the system more than once, because they cannot control their temper. And when they get mad, they lash out. And if they have a firearm, they lash out with the firearm. And Representative Filippi has made some very cogent arguments about the civil side of things regarding the restraining orders. And he has asked, in what other civil capacity can you lose a constitutional right by preponderance of the evidence? And I'll say the same thing here I said in committee. You lose your right to association, or it's curtailed in some respect, when a judge, after a hearing, makes a finding of fact that a person is maybe a domestic abuser or has in fact abused somebody and says, I'm going to put a restraining on you. Person A, abuser, you keep away from person B, the victim, for 3 years. That is an aggressive limit on someone's First Amendment right of association. It's done by preponderance of the evidence. And the firearm ban that we're talking about today falls right in line with each of those reasonable situations where the government is forced to intrude on someone's constitutional rights to protect society as a whole. It's a tricky balance. We deal with it in court every day. But there is nothing in this bill that is an outlier. Thank you, Mr. Speaker.
Representative Chippendale.
Thank you, Speaker. To address some of the comments that need to be clarified, it was stated that this bill is a compromise that addressed the needs of the opponents. I think we've all received the same letter that clearly indicates this is not supported by the opponents, never was. I also have to correct the statement that a misdemeanor can lead to the confiscation of all your personal property. It doesn't even go that far. A simple appearance in civil court, where you have no right to counsel, by the way, you can lose your personal property and your constitutionally protected Second Amendment rights if you appear in civil court, in family court. And the family court judge is always going to err on the side of caution, as they should, and issue a restraining order. There's no finding of fault. There's no finding of guilt. No one's been convicted of anything, not even a misdemeanor. And their personal property is seized. This is America. In the context of that, think of it. Their personal property is seized. Their constitutionally protected, God-given Second Amendment right is violated on an accusation. That's what this bill does. We heard that 28 states have this same language and that South Carolina just passed a bill with the same language. It wasn't identical language, but worse than that, the underlying statutes surrounding domestic violence in the state of Rhode Island are very different from all of those other states. So while a bill may mandate the same things or similar things to another state, the underlying statutes on domestic violence are different. And I'll give you an example, because we have heard cyber stalking, vandalism. So someone gets into a fight with a cohabitant of their house, and on their way out, they don't want to get into a physical altercation, so they decide, I'm going to leave. The smart thing to do. They get out, go in their car, open their door, accidentally ding their roommate's door next to them. They've committed vandalism by the statute. Party one walks into the house, and party two is on the computer having an illicit computer video chat with their person that they shouldn't be having a video chat with. And that person gets so angry, they walk up to the computer and turn the computer off. Didn't touch the person, didn't verbally assault the person, didn't even say anything to the person. Just turn the computer off. I don't want you talking to your boyfriend on the phone, on the computer. They just violated the cyber stalking statutes. It's not just the bill that we're looking at. We're looking at all of the statutes underneath it that this impacts. Civil libertarians, or people who consider themselves civil libertarians in this room, should cringe at the notion of this bill. Should cringe at it. We just learned the Chief of Police Association in the state of Rhode Island is opposed to this bill. They voted. I have the email right on my phone. They are opposed to this. Why? Because we are going to mandate that they implement a system of tracking all of this seized personal property. They're going to be liable for it. They're going to have to develop procedures for it, ways to track it. They don't have the manpower and they don't have the resources. But yet we're piling on another unfunded mandate to the people who should be on the street protecting us, but are back in the office doing paperwork and taking care of people's seized personal property. And just to correct another thing, we don't have a right to firearms by virtue of the Constitution. We have a right to firearms by virtue of the fact that we're human beings, and that's a God-given right. The Constitution protects it. At this point, I'm done. Thank you.
Representative Tanzi.
Thank you, Mr. Speaker. Of course you can have a lawyer. Has anyone heard of any proceeding where you couldn't? My bill doesn't change that. You can have a lawyer, whether this is the conviction side or the restraining order, court-ordered protective order side. And protective orders do have a lower standard. Absolutely. It's in the law. And they should, because they're temporary. And there's a due process for that. And convictions should be a higher bar because it stays on your record. And the consequences are longer as well. And they're not permanent in this bill. So a conviction is not a permanent ban. I will tell you that the federal standard has made it so that it's a permanent ban, but our state is the one who prosecutes these cases. So we are putting on a 6-year prohibition to convictions. 27 other states do this. And I spoke to some of you about what it takes to get to a conviction, right? There's a lot of what I'm calling off-ramps. We have a person who's been abused. We have the abuser. Chances are that this abuse has been going on longer than the first time, right? The time that asked them, made that person want to call the police, made them want to pursue something in the courts. So the fact that the person gets away with a lot of a history of that is substantial. We also have off-ramps for dismissals, and we know that these charges are often pled down. So we have many opportunities for people who are maybe just haven't seen the light yet, right? Maybe we needed the court to intervene and have them see the light. The bottom line is this bill is a very reasonable response to a problem that exists in our state. In 2016, there were 10 domestic violence homicides in Rhode Island, and 4 of those were at the result of a gun. From 1980 to 2016, we started tracking this data in 1980. From 1980 to 2016, 48% of all domestic violence homicides were committed with a gun. 232 deaths. If we could have taken the guns away from 10 of those people to have saved the lives of a portion of those people, to me is worth a temporary ban. That is, in fact, what this bill is about. I know people will try to bring it into other subjects and try to make this about prohibition and confiscation and violation of Second Amendment rights. There are other times when the courts take away second rights, and even just with a restraining order. We take away people's speech, their right to speech, their right to assembly, their right to property, their right to association. Right there, that's what the restraining order currently, under state law, those are fundamental rights that we take away from people when they're restrained. They can't talk to the person. They can't go where that person is. They have to potentially give up the home that they live in. They may even own that home, but the court process allows for that person to have their home taken away. And association. It says who you can and cannot associate with, and very specific terms. So I'm sorry, I don't buy that there are no other times in existing law where people's fundamental rights are taken away. I just named 4. And I'm not a prosecutor, I'm not a lawyer, but I know enough to know that these are reasonable restrictions that in the end will protect lives. So thank you, Mr. Speaker.
Whip Philippi.
Thank you, Mr. Speaker. I'm just going to go through the list of some of the comments that were made. As to the right to counsel issue, I think what my colleague was saying was that in criminal prosecutions, you have a right to counsel where if you can't afford one, the state has to supply one to you. That would not exist in a civil restraining order. proceeding. So when you go to the district court and you're poor and you have no money and you're about to have your Second Amendment rights stripped from you, you don't have the right to force the state to pay for your lawyer like you do in a criminal prosecution. I think that's the issue that he raised. As to Representative Knight's comment that with a misdemeanor we take away liberty interests all the time. Yes, but the court has discretion. Those convictions may be put in jail for 6 months, may be subject to a $1,000 fine. It's very different in this context to say, shall hand in your firearms. It's very different to take away judicial discretion. If some of those misdemeanor statutes said, shall go to jail for 6 months, all of us would have a problem in here because it's taking away judicial discretion. And as to the notion that you have a right to interact with someone when you're restrained, I agree. The court should keep you away from someone who doesn't want to talk to you. I don't believe you have a fundamental right to interact with a third party, but you do have a fundamental right, a personal right, to keep and bear arms. I think it's a very important distinction when the court says, stay away from that person. It's very different than saying, hand over your firearms. Let me see. Yes, as to the points raised by Representative Tanzi, the court can take your property, which I think means the court can tell you you have to leave the common domicile. The court can restrain who you speak with. In all of those instances, the court may do that. The court may take your property. The court may restrain you from interacting with someone. This bill says the court shall take away your Second Amendment rights. I personally think this is a slap in the face to our judiciary. Right now, they have the discretion, which they exercise every day, as to whether or not to take away someone's firearms. They already have that ability under the statutes we're dealing with. The court may take away someone's firearms, just like they may put someone in jail. They may order you to leave the common domicile. They may order you to stop talking to someone. This is shall. And the fact that we don't see that it's an enormous problem to take away someone's rights and not give the court any discretion as to whether to do so or not, the fact that we're not recognizing that and we're conflating it with all of these other discretionary decisions on behalf of the judiciary, I think is dishonest. And I think it isn't dealing with the real issue here. Preponderance of the evidence shall take away someone's constitutional rights. Show me where else that happens. Not may, Representative Knight, shall. Show me where else that happens.
Representative Hearn.
Thank you, Mr. Speaker. I rise in strong support of this legislation. This makes sense legislation simply takes away a weapon from a habitual violent abuser. These aren't your guys just off the street who got in trouble once. These are habitual, the worst of the worst. They are terrifying and threatening and often killing the women and children who are putting their trust in them. I think it's a horrible problem to see a habitual violent abuser being defended in this chamber. I just urge everyone to pass this important legislation to keep these families safe. Thank you.
Representative Price.
Thank you, Speaker. Well, I've heard a lot from my colleagues and on both sides, and I'll just give you my 2 cents on this. I sat through the committee hearings. I've heard from constituents. I've talked to both sides, and my conclusion is that the testimony in the committees was misleading at best. Their statistics were skewed. They didn't include a lot of the stabbings, hangings, beatings, strangulations, other weapons used. They just included firearms. Most of the survey was not done statewide, and it wasn't a true representation of the population from the over, I would say, well, we all got them, 1,200 emails. The majority of them were against this bill. Those are our constituents. And I understand, I should start this out with domestic violence is a bad thing, it's very bad, and I'm certainly against it. This bill, I see the attempt to try to address this with the firearms. I understand that. But the unintended consequence of this could be devastating. And back to the other part of the some of the disinformation that's being spread. The NRA does not support this. I have a letter here from the NRA that says they do not support this. They're against domestic violence, but they say that the unintended consequence of this bill, let's see how they said, it could potentially have harsh consequences on innocent individuals. I know that sounds hard to accept because we're talking about going through the court system, but I'll look at the bill right here. It says on page 1, line 16, it changes the word from defendant, so you're no longer defending yourself in a court of law, to a person restrained. I know people that have been restrained for false pretenses. I believe there's quite a few of us in this room who probably have heard about the same situations. The part about the nolo contendere on page well, when people, it's in the bill. So when people plead nolo contendere, in Rhode Island, that's an admission of guilt. Some people plead that because they don't have a public defender. They can't have a public defender because they're financially don't have the finances for it. It's not provided in family court where this is first handled. So they'll plead nolo contendere. And that right there, they're going to have to turn their guns in. And no longer with a third party, which is another question I might have for the sponsor or someone that's representing the sponsor. The third party issue. In committee, I asked the question if there was an example in Rhode Island where firearms were transferred over to a third party, where that party that transferred the firearms went and regained possession of the firearms and committed a domestic violence crime or any kind of a crime. There was no examples. We're addressing something in Rhode Island that we don't have any examples of something that's happening. The testimony came from Everytown, USA, which is backed by Michael Bloomberg, who's a known, he's a known anti-gun person. All the testimony they had would reflect on stuff that was going on around the country, where we as a body address Rhode Island issues. It's a Rhode Island issue. If it's an issue, then we should address it, not having some outside source come in, and start to decide what we're going to address.
30 seconds, Representative.
Okay, thank you, Speaker. Representative Knight called it a firearm ban. You are absolutely correct. I finally have agreed with you. It is a firearm ban. And one quick question for the sponsor. or someone, enforcement. You have 72 hours to turn in your firearms. How is that going to be enforced? And what is the enforcement that's going to take place after 72 hours? Is it going to be the state police knocking on your door, confiscation, searching your house? Or maybe someone could answer that question for me.
Time, Representative. You could, of course, get up again.
Thank you.
Representative Walsh.
Thank you, Mr. Speaker. As long as we're talking about misrepresentation of facts, I'd like to point out that I only got 300 no emails. 12 sounds impressive. Additionally, if we're talking about facts, the Constitution doesn't give us gun rights. The Second Amendment does. And as one of my colleagues mentioned, you can't change the Constitution. We have. We've done it 28 times and counting. As we're under the impression that mostly only adults are allowed to own weapons, as far as I'm pretty sure a 5-year-old can't go to D&L and buy a rifle. Perhaps I'm wrong. But Representative Filippi brought up a couple of interesting examples in terms of roommates throwing books at each other or getting drunk and you know, a little erratic. And my thing is this: you have to be an adult to own a gun. Okay, so if you can't have an argument like an adult with your words and not your hands, you shouldn't have the opportunity to own something that was designed specifically to kill people. Cars were designed to get you from point A to point B, but you still have to prove that you know how to use it, that you know how to drive it forward, park it, back it up. Guns were specifically designed to kill people. But I, as a gun license holder myself, know that when I purchased my firearm, I was not required to prove that I knew which end the bullets came out of. I was not required to prove that I knew what to do in the event of a jam. I was not required to prove that I was any good at it. I was lucky enough to have a significant other who was in the police force, and so he taught me everything that I needed to know. But I was not nearly as pro restrictions until I got my gun license, because I found that it was wildly irresponsible how little you have to know. And I recognize that when I use this argument a lot of the time, I get driving is a privilege, not a right, and guns are a right. And that's, you know, something that everybody can decide for themselves. But I, as a gun owner, would gladly give up my weapons if I were being, if I had a restraining order against me, or if I were being charged, because it is worth it to me to let you know that you're safe. If I have no intention of hurting you, then I'm fine with a 72-hour wait to determine whether or not I'm actually an abuser. I don't think that that's an unreasonable thing, and it disappoints me that a lot of other gun owners in this room don't feel the same way. Thank you, Mr. Speaker.
Representative Newberry.
Thank you, Mr. Speaker. Ladies and gentlemen, I actually was not planning to say anything on this bill because most of what I'd want to say has been said very well by a lot of other people in the room. But I did want to address one comment. I've been listening to the entire debate, and I actually think this is a very good debate. We don't have good debates in this chamber probably as much as we should on important issues. I almost called for a point of order at the time, but I didn't because I didn't want to get into back and forth and disruption. But there was a comment made by my good friend, Representative Hearn. We got elected together. I think you're one of the most honest people in here, and I know you're very passionate about this issue, even though you and I don't agree on it. But you said a while back that you're upset that people in this room are defending habitually violent offenders. And that's not what this is about at all. Nobody is defending habitually violent offenders. I don't want that soundbite even out there because it's just completely not true. In fact, under existing law, any judge worth their salt is going to deal with habitually violent offenders properly. This bill is precisely going to end up targeting and hurting the people who are the exact opposite of an habitually violent offender. And I'm not going to go through all the examples that have already been given. I don't want to use my full 5 minutes. I actually want to sit down. But the one thing I'm going to say is this. In 2013, after Sandy Hook, those of us who were here, there was a bevy of gun legislation bills that were introduced. And I sat through the Judiciary Committee hearings, and the one thing that really became crystal clear to me is this. Gun control laws, and this is a gun control law, you can couch it the Rhode Island Families Act, Protect Rhode Island Families Act, it's a gun control law. Good or bad, that's what it is. Gun control laws are wildly misunderstood by the public. This legislation is flawed, and I think anybody that understands the legal system really well, and I think most people in this room deep down, even if you are passionately anti-gun and see this as a stepping stone to something else, know that as written, this is a flawed piece of legislation. Nobody's defending domestic abuse. People are defending people's constitutional rights. This is not a good bill. I'm not going to belabor all the reasons why, but I'm talking more to the public now. People who are interested in gun control issues, whatever your philosophical point of view may be, across the spectrum, before you really delve into these things, understand the laws and the proposals that are being made, because there's more misinformation, in my opinion, pro, con, whatever, on gun control laws than any other issue in this entire country, state, federal, or local. So please understand it before you make your decisions and do what you ever think is right to do for your constituents. Thank you.
Representative Quattrochi.
Thank you, Mr. Speaker. There's no possible way that I could be as eloquent as my colleagues who stood in opposition here, but I really do want to make my voice of opposition heard. One of my proudest moments in my life was to stand here with you folks and hold my right hand up and take an oath to protect our constitutions. I take that very seriously. Many generations of folks have given life and limb to protect our constitutions. Benjamin Franklin said that those who would give up liberty for a little temporary safety deserve neither. I'm sure that many of you have heard that before. I take that seriously also. We do a lot of promising of safety in this room, in this building. A lot of industries, whole industries are built on the promise of safety. I won't be voting against our Constitution today. Thank you.
Representative Regenberg.
Thank you, Mr. Speaker. We can't keep saying domestic violence is bad and then not do anything about it as a disclaimer. We can't keep saying it's a shame when someone is killed by their domestic abuser with a gun, but then refuse to take any substantive action to protect our constituents. It's pretty rare in this room that we have the chance to vote for legislation that will concretely save the lives of Rhode Islanders. We have that chance with this legislation. I'm incredibly grateful for the huge amount of work that the bill's sponsor has put into this, and so I strongly urge my colleagues to vote for this bill. Thank you.
Representative Roberts.
Thank you. My email has been slammed with people who oppose this legislation. This takes away rights from people who have never even been convicted. I don't see how that's right. And not only that, it makes it very difficult for them to get their rights back. They have to go through a lot of red tape. It is not fair. Most of these people, or not most, I'm not going to say most, I can't speak for most, but a lot of them, it will affect the poor, and how are they supposed to afford a lawyer? That's who it's going to affect. It's not fair. So, actually, there are actually many laws in place right now to stop convicted felons from getting arms in their hands, getting firearms into their hands. So the laws are sufficient. We just need to enforce them. We don't need to make more. It's not that any of us agree with domestic violence, but we shouldn't make the innocent pay for that which these felons are doing. Maybe we just need to make our laws tougher. Those people who are felons, keep them in jail longer. Why should the innocent people suffer? It's not right. That's all I want to say. Oh, actually, one more thing. Now, people can also, if you get some crazy person who really wants to kill someone and they don't have a gun, guess what? They're going to find another means to do that. They'll hit them with a car if they have to. And what are we going to do? Are we going to outlaw cars? That'd be ridiculous. I urge you to vote against this bill. Thank you.
Representative Price.
Thank you, Speaker. Just want to draw attention to page 4, line 21. if you notice, the wording has been stricken out that says, who has been convicted of a crime. This bill is going to punish people that have not been convicted by a crime. The acknowledgement of domestic violence being a problem, I would like to agree with Representative Regenberg. It should be addressed. And I'm sure it must be a problem in Rhode Island, but is this addressing the real problem in Rhode Island? Or is this going after a certain group of citizens and residents? Because if we wanted to go after domestic violence, maybe we should make illegal stabbings, fire, hanging, beating, strangulations were the majority of the weapons that were used. Just according to the statistics from every town, when you dive into them. I'm in no way saying that domestic violence is okay. I'm just saying that this bill, I sat through committee hearings, long committee hearings where the public got to testify on the original bill. And then we're presented with this, a much longer, much more in-depth, I would say probably a worse bill than the public had the opportunity to testify in front of. Now we're going to be faced with this, passing this on the House floor, when it really, there's a reason that it's been 3 years in the making, because they're changing law that was last revised in 1994, except for last year when we mirrored, and that's another thing, it mirrors federal standards now. This will exceed federal standards. So we're changing something that's been there since originally in 1985, then changed in 1994, changed a little bit last year, and now we're going to drastically change it without the public's input, without being properly vetted further. I commend the House Judiciary for their vigilance and listening to the public on this issue and hearing all sides of it. But this is very different from what we had in public testimony. I would just like to see that the public has more input on what we're voting on for the public, and give the public more opportunity to engage it. Thank you.
Representative McEntee.
Thank you, Mr. Speaker. I rise in strong support of this bill. As a member of the Judiciary Committee, we heard a lot of testimony from Rhode Islanders who had been victims of abuse. And one woman really drove it home for me. She had been a victim for many years, both verbally and physically abused by her partner. And at all times, he left his gun right in the middle of the table for her to see, to know it was there in case he needed it. No one should live under that kind of fear. What this bill does is it takes the right to carry a weapon away from those who have abused their right to carry. They no longer deserve the right. If they can't control themselves and be in a civil relationship with those around them, then why do they need a gun? And I'm going to tell you, as an attorney, I've been on both sides of this. I've represented domestic abusers, and I've prosecuted domestic abusers in my many years as a lawyer. And one of the problems that I have seen over and over in my experience as a lawyer and as a probation officer in my former life was that many of these people get back together. They have a reconciliation after a certain amount of time. We may not be able to keep them away from each other, even if they're in an abusive relationship, but we can take their gun away and take that gun off the table. And I'm asking you today, please vote for this bill. The problem is greater than you think. I practice in family court every week, and restraining orders are commonplace. Violent relationships and divorces are commonplace. Take the gun away from those who have abused their right to carry. Thank you.
Representative Ranglin Vassell.
Thank you, Mr. Speaker. I rise in full support of this bill. I just want to address something that was said earlier by saying domestic violence is not about class. Domestic violence is really about one person exerting power and control over another human being. Domestic violence is a public health issue. I don't know what I would do or say to a group of women who convened at a conference a couple weeks ago, or a couple months ago, I should say. It was a forum around gun violence and domestic violence. And I listened intently to the women who spoke of their experiences. And I stand here today to say I am in full support of this bill because these women are not in the chamber at this moment, but I am here. And all the advocates who really want to see good common sense control pass is here as well. So for me, I just want to reiterate in conclusion that it's really not about class. We shouldn't confuse these facts. This issue is really about one person trying to exert power and control over another human being. Thank you so much.
Lita Morgan.
Thank you, Speaker. I want to make it perfectly clear to everybody in this room and outside of this room that those folks that are opposed to this bill are not trying to protect habitual domestic abusers or dangerously violent domestic abusers. What we are trying to protect is law-abiding citizens' right to own a gun, and that is protected by our Constitution. The problem with this legislation is that it does not target habitual or dangerously violent abusers. It removes judicial discretion, and that's the discretion, that's the system we are using now. A judge knows if somebody is habitual. They know if they've been before them before. They know the circumstances of the restraining order. They can use their discretion to take someone's gun away. No one who opposes this bill thinks that domestic violence is a good thing. But judges can do it now. This bill removes that discretion. I just think it's unbelievable that when we said jail time was removing a constitutional right, that we forgot that a judge does that. He uses his discretion. Searches and seizures, we are protected from unreasonable searches and seizures. That's what a warrant is for. And guess what? A judge uses his discretion on that. In civil proceedings, too many people will plead nolo contender because they don't have the money for a lawyer. And that removes judicial discretion. And that's where this bill goes too far. The system works now because a judge can do this, can remove guns from a habitual offender. It is very misleading and offensive to be charged with protecting horrible people because we're defending a constitutional right. Thank you.
Representative Tansey.
Thank you, Mr. Speaker. So we talk about what other states do this. We talk about how difficult this bill is. And I'm grateful for the discussion. I really, truly am. It's been going on with my name on the bill for 3 years. I know that Representative Amore came years before me and attempting to pass a similar piece of legislation. We are not outliers in this. I just want to point out prohibition for domestic violence restraining orders. 27 states plus DC, okay? We're not talking about all the East Coast liberal states that everybody's probably imagining. We're talking about Alabama, Colorado, Minnesota, North Carolina, New Hampshire, the Live Free or Die, New Hampshire. New Jersey just passed a law that's a little bit stronger than this one, my home state. And every single Republican unanimously voted in support of this in the New Jersey Senate. This isn't a liberal conservative debate. This is a life-saving debate. We have Texas on the list for prohibition for domestic violence restraining orders. West Virginia, Oregon, Tennessee, Utah, another state that I hail from, Utah, which just passed it this year. Convictions, 13 states plus DC require defendants convicted of misdemeanor crimes of domestic violence to turn in their guns. Again, Colorado, Washington, D.C., Nevada, Minnesota, Tennessee. These are states all throughout our country. I want to be that voice. I want to make sure that people who need our protections, who have the courage to stand up and leave a domestic violence relationship, know that we have their backs. Because the statistics don't bear out so well for women and men and children who live in domestic violence situations. Every single child since 1980 in the state of Rhode Island who was murdered in their home in a charge of domestic violence was done so by a gun. Every child since 1980. Again, not cherry-picked statistics. This is the year that the Coalition Against Domestic Violence began keeping statistics. Not cherry-picked, folks. Every child was murdered with a gun. We're starting to get a bigger picture, right, of what murders, domestic violence murders are. Oftentimes, these are mass murders, where murder of 3 or more people are happening. Every single bystander, whether you're a coworker, whether you're a brother or a sister, whether you just happen to be in the same place as a victim of domestic violence, every single bystander that was murdered during a domestic violence homicide in the state of Rhode Island was done so with a gun. We're not just talking about the victim, the survivor. We are talking about our neighbors, innocent people who have nothing to do with a dynamic, with a relationship that is so complicated. We're talking about protecting all Rhode Island families. That's why it got its title. And I want people to think about that, have that first and foremost in their minds when they think tonight. When you commit a crime of domestic violence, let's just say the good guys and gals who have their guns, there's a system for them to maintain their rights. This bill is so narrowly written to just affect those who truly are people who
30 seconds.
should not have guns. It's just that simple. If you can't control your anger, control your emotion, control your hands, then I will be that voice, and I will say that I will stand between you and the person who is guilty of abusing you. And I urge my colleagues to stand with me tonight. Thank you, Mr. Speaker.
Representative Amori.
Thank you, Mr. Speaker, members of the House. I stand in support of this bill, and I absolutely do not question the intent of the opposition. I believe it is based on principle and constitutional interpretation. I'm actually proud as a Rhode Islander to hear Whip Filippi and Representative Knight discuss this in such detail. As Rep. Tanzi mentioned, I've put a similar bill in since I was elected. One of my constituents asked me to do so. She lost her daughter in a domestic violence incident, and I admit that I came to this chamber with some preconceived notions about weapons. I thought I knew. When I got here, I tried to listen and listen carefully to both sides of every issue, whether it be a discussion about assault weapon bans, which I'll admit to you, when I arrived here, I thought that was a logical move to make. I don't think so anymore. I've been moved on that. Whether it be magazine capacities and the limits on them. I arrived here thinking that was a good idea. I've been moved on that. I don't agree with that any longer. I consider myself a pretty reasonable person when it comes to our constitutional rights. And I consider myself fairly knowledgeable about our constitutional rights. And as Representative Knight mentioned, our rights can be restricted. They have been restricted. I have not been moved on this particular piece of legislation. And I have heard both sides, and I have listened intently throughout my 5 years here. I have not been moved on this. I support this legislation because I believe it's common sense legislation, and it does not affect law-abiding gun owners. Thank you, Mr. Speaker.
Chairman Craven.
Thank you, Mr. Speaker. I agree with Representative Amori. To cast any dispersions upon any member or the intentions of any member of this body is not only inappropriate, but it appalls me. So if any such feelings have been cast upon any of the Republican members, I would apologize for that. It's not my intention, but I don't think it's the intention of this bill. We have a fundamental difference in how we see this issue. Like Representative Amori, I came to this chamber with a lot of preconceived ideas about guns. I saw what they did to people, up close and personal. Dead bodies. As a prosecutor, that was part of my job. However, when we had the hearings in the Judiciary Committee, shortly after I arrived here, in reference, right on the heels of Sandy Hook, I asked the chairperson if I could ask the first question of the Chief of Police of Newtown, Connecticut. And I asked him this question. Chief, you've probably done about a month and a half's worth of investigation right now. Have you read the 6 bills that have been submitted for hearing tonight, for passage or for at least consideration? He said yes. I said, I have one question. If any of those bills were in place at that time, at Sandy Hook, or a week before, would it have made a difference? His answer was one word: no. So I understand the issue of gun rights and the sometimes emotional reaction to emotional things. But here we have a question of deaths. We addressed this as a nation in 2001 with 9/11. We passed the Patriot Act. There is no protection to what the government says is an appropriate intrusion into my constitutional rights, either by way of my cell phone or by way of a computer. If I fit a profile, the government has a right to invade my privacy. That's my Fourth Amendment right and my First Amendment right. In this instance, we're talking about the Second Amendment right. And what Congress did with the Patriot Act was intended to save lives, and we all applauded it. Now, the greatest constitutional scholar who was a strict constructionist, we recently lost him last year, Judge Scalia. And Judge Scalia, in what I think the seminal opinion about gun control and gun rights, it was District of Columbia versus Heller. And I'll end with this. These are his words, not mine. Like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commentators and courts routinely explain that the right was not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. This is a reasonable balancing test between a problem of domestic violence and deaths and the Second Amendment rights that we speak of here today. I believe it is a fair balancing test to a limited group of people to prevent what is the worst thing we could ever do in this body. Be responsible in any way, shape, or form for not acting and not protecting lives that are in danger, probably as we speak. Thank you, Mr. Speaker.
Representative Chippendale.
Thank you, Speaker. We heard that the Patriot Act in 2001 was applauded by everyone. Who said, Patriot Act, we all applauded it. There was no such applause for the Patriot Act. There were screams from every building that this is the biggest violation of our civil liberties in the history of this nation. The Democrat Party, the Republican Party, many people got up and argued that. We don't take the government putting their jackboots on our throat and stripping us of our rights and say it's okay, ever. We also heard we can take guns away from abusers with this bill, and we should. No one, despite the inclination to believe otherwise, no one will disagree that people who are abusers should not have firearms. That's not what this is about. This is about, again, what this bill does. And it's not very narrow. It's very broad. It's the exact opposite. An accusation against someone and an application for a restraining order. That's all that's needed. No finding of fault. No criminal wrongdoing. That is not an abuser. That is not the habitual criminal violators. Those folks are already in this. Our laws deal with that. Not a single case was presented to anyone in this body or found by anyone who's researched it to support the claim that people who have been subject to restraining orders in the state of Rhode Island violate them by using a firearm. Not one case, even from the very well-funded and well-researched opposition. None. It's never been an issue in Rhode Island. So we're going to cast this wide net. Because if we can save just one person, shouldn't we? That's a great argument, but it falls flat every time it's used. If we were concerned about saving one person, we'd have a fireman and a policeman in front of everybody's house. You have to balance it. We have civil rights. We can't flush them down the toilet on an accusation. Make no mistake, that's exactly what this bill does. Precisely what this bill does. The courts are opposed to mandated actions. They've expressed that to us every year when we go to their reception. We hear it all the time. The police are opposed to this because it places an undue burden on the police department. Over 30,000 criminal cases go through the court system in the state of Rhode Island, many of which are domestic cases involving exactly what we're talking about here. How are they going to catalog that kind of personal property after it's stripped from its rightful owner on an accusation? Let's come down to earth, put the hyperbole aside. We are taking a constitutional right away from people simply because someone accused them of something they may not have done. That's the bottom line on this bill. Thank you.
Last light, Leader Shikachi.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, as was stated earlier, I cannot tell you that I believe this is a proud day for this institution, where we can debate an issue on the merits, and I don't question anybody's motives as to why you're for this bill or against this bill. What I just want to point out, and I want to be very brief, Mr. Speaker, is that our neighboring states of Massachusetts and Connecticut, as well as all the other states that are listed, have this protection in the law, as do several others. This is a domestic violence bill. It's designed to ensure the safety and protection of victims of domestic violence. Let's not forget one thing, the discretion that we're all talking about. There's two types of discretion. There's discretion in the penalty, and that's what I think this bill addresses in terms of the removal of a firearm. There's still discretion by a judge whether to issue a restraining order. No one loses that protection. Restraining orders are not automatically granted. You have to go before a judge, and he still retains the right to whether he's going to issue one or not. Based on that and all the testimony, Mr. Speaker, I urge my colleagues to vote green on this bill. Thank you.
There are no other lights. Clerk, unlock the machine. All in favor, please vote green. Those opposed, red. Clerk, lock the machine. 55 in favor, 12 opposed. The act prevails.